Yes. Thank you. Mr. Bueller?
Good morning, Your Honor. On the issue of spoliation, there's a jury instruction, and we believe there's been no shred of evidence presented in this case that the plaintiff had a GoPro video. He denied he had a GoPro video. The only evidence is an email from his daughter who says, "Oh, I can't believe there's a GoPro." And
That was the testimony of the daughter as well, Shay.
yeah, that's who I'm referring. But that doesn't mean. I mean, it could be anyone that had the GoPro video. Could have been the Deer Valley. Could have been anyone. But there's just absolutely no evidence. It was a mistake, and it would be absolutely erroneous if the court gives this jury instruction, because other than that mention in that email, which the defense, and there's been no evidence at all brought in this case that there's anything to it, would be clearly erroneous, and therefore we request that the spoliation issue be stricken from the instructions, as it would prejudice the plaintiff on something that has no basis, has not been proven. They have nothing. In fact, the late produced meetup.com comments verify that, because the defense had been saying or implying or insinuating that, oh, the GoPro video must be in that stuff because it was mentioned in that same email chain with the daughter, Shay, and there's just nothing there.
Okay.
Thank you.
Thank you. So I'm going to deny the directed verdict motion on the spoliation instruction. The defense, have you reviewed the instruction? There's a new one that came out,
Yes.
removing the word "the" from the bottom.
It's acceptable.
Okay. And Mr. Bueller, I mean, you're certainly welcome to submit or request to the court some additional interrogatories so that it's clear from the record whether the jury made findings under spoliation or not. I think it could track the instruction itself. That way, if there's a verdict that's adverse to your client, you would know whether the spoliation instruction, whether there was any inference taken by the jury on the GoPro video.
Yeah, it gives more credence to the lack of evidence of this. So we'll consider that, and I guess we would have to do that pretty darn quick.
Yes, we would. I think that the daughter Shay testified that when she got off the phone, she thought there was a GoPro video, and I think reasonable inference from that, the jury could decide that there was a GoPro video and that your client had some control over that video. They could make that decision.
Right, but there was no evidence that he had control over it. It was just there was one. It was mentioned, and it means that every time a piece of evidence that's mentioned that turns out to not have any basis, then it becomes a spoliation issue. We think that's an erroneous level of proof. I've got two others, or actually, and then finally, do you mind if I go ahead now, Your Honor?
Go ahead, please.
Okay. On the issue of negligence, and I'm going to talk about both defendant's negligence and plaintiff's negligence. On defendant's negligence, at least for the record, we assert that there should be a directed verdict on liability, causation, and damages, and that is based on the evidence that's been brought before the court. Likewise, on the plaintiff's side, on the defendant's side, we should have a directed verdict in favor of the plaintiff. On the plaintiff's side, the charges from the defense against the plaintiff on the issues of liability, causation, and damages should also be brought. And I could summarize the whole case, but I don't think it's necessary. I think the court realizes that. But if you'd like, I could add more detail for the basis of that directed verdict motion. Two of them.
Are we talking about the $1?
Yes, the $1 that we would owe you. That's the second one. The first one is a directed verdict in our favor for our damages, liability, causation, and The only issue would be the amount of the damages for us. So I combined them two, so it's actually two directed verdicts with three subparts each: liability, causation, and damages.
And I have given it some thought, anticipating your motion, and based on my review of the evidence, I would deny both motions with all three parts in both motions.
Okay, thank you, Your Honor. Then I have one other. It's not a directed verdict motion, but it's a motion to take judicial notice of Terry Sanderson's life expectancy according to the Social Security Administration life expectancy tables and calculation. This is something that's commonly done. I'll just advise the defense that we're planning to use in our closing reference to the life expectancy of Terry to calculate a per diem.
Have you disclosed to them what number that you plan to use?
Yes, I'm ready to do that right now. It's, they change with each day.
Right.
And I've got one for the court too.
In principle, does the defense have any issue with that?
Well, he's got 20 some odd health conditions, some of which are impact life expectancy. So I have some problems about it, but it'd be nice to know what they want.
Yeah, we're actually going to go lower than that. Would you like to approach?
Sure.
10 additional years.
Yeah, just 10 years, even though it says 10.8. It could be argued that Terry's he's a non-smoker. He has other health factors in his favor, that he's conscious about his health, and so we just want to, in closing argument, mention that he has a potential life expectancy of this, and then argue that on a per diem basis for his future non-economic damages. Non-economic damages, as you know, are not precisely derived. They have, it's more of a subjective viewpoint of the jury and the parties' arguments in favor of.
How about to address the defendant's issues with, the comorbidities, let's call them?
They can argue that too.
I realize they can argue that, but how about to address that if what the court takes judicial notice of is that a person who is 76 years old has an approximate life expectancy based on the Social Security tables of 10 additional years?
Yes.
Is that,
Your Honor?
that way I'm not taking judicial notice of the plaintiff's life expectancy, but rather what the Social Security tables say.
Right, Your Honor. And
Or I'll give you 5 as it relates to Terry.
I know what they are, counsel. Let me just say this. We don't plan to reference the Social Security tables. It would be just as simple that statement that Terry's life expectancy could be calculated at approximately 10 years. And the past 7 years since the trial date. I mean, it's like taking cognizance of the.
How do I make that conclusion because it involves an individual?
Oh, you don't have to make the conclusion. I'm just.
You just laid it out. I would.
Well, I'm just previewing what the closing argument will mention, and that it's not evidence in the case. It's argument.
If I'm taking judicial notice of it, it is evidence.
Well, I don't think the court needs to take judicial notice, but if the court would like that, we did produce this. I'm just giving you a preview in the defense counsel that we will be making this argument that he could potentially have 10 years of life, and that that's the basis for our damage claim. And then we're not raising it to the level of something evidentiary. It's pure argument for calculating non-economic damages.
Okay. Mr. Owens?
I don't have an objection to Your Honor's approach, which is under Social Security tables, a 76-year-old man is expected to live 10 more years.
And Mr. Bueller's is proposing that not what happened, but that they just refer to it in closing argument. I mean,
yes.
Not that they don't refer to any particular table, but they just say, a man at his age, he's probably got about 10 years. Do you have any objection to that?
In its argument. But if the court is inclined to not prohibit the plaintiff from making that argument, then we would ask that the court take judicial notice of what I just gave you.
They can argue it. They can argue it.
Okay, so you can argue it without any reference to the table or me taking any judicial notice.
Unless counsel wants reference to it or the court does.
If you're going to talk about Terry, I'll stipulate to 5.
No.
Okay, then we'll keep it as argument.
Okay, which brings up a very important point I wanted to raise. There have been a lot of evidentiary objections during the trial that a particular question misstates prior testimony in the case. What I want to avoid is a lot of that kind of objection happening during closing argument. That hey, he's not saying what really happened here in trial, or he's misstating what really happened here in trial. I don't want to see a lot of that objection during closing arguments, because my reaction will be the same as it has been throughout the trial. The jury will remember what people said. So if you think that the other lawyer or lawyers say things that aren't supported in the record, then bring that up in your part of the argument.
Fair enough, Your Honor.
And so because what I expect you to do, with this one exception of this 10-year thing, I expect you to tether your arguments to the evidence that was in front of the jury and any reasonable inferences from them. Not to bring in outside data, not to bring in outside evidence, but just the evidence that was here in this courtroom. Okay?
Just to give you a sample, we would argue that Terry has approximately 10 years left, at least in his life. He's lived a healthy. He's not a non-smoker.
No objection.
And there's not any objection to that.
Thank you.
Okay. Turning now to the jury instructions, does anyone wish to object to any of the closing jury instructions that the court put together?
We're reviewing them. I know you gave them to us yesterday. Give us one moment, please.
The only one that we might have a small suggested change or objection to, Your Honor, is the spoliation.
Can you speak up?
Sorry, it's the spoliation instruction that we have here.
Okay.
It's that first sentence. We don't believe that there's been any evidence that Mr. Sanderson was in possession of a GoPro, and so we would want the first sentence to be changed to, Ms. Paltrow has presented evidence that a GoPro video of the ski collision may have existed. Sanderson asserts that the GoPro video of the ski collision never existed. So it would be because there's been no evidence put on that he possessed it. There's been an inference of that, maybe at best, but it's, again, coming through his daughter's email to him.
I think that's a reasonable request.
Because there's been no evidence of his possession.
It's more neutral, I think.
So it would read now.
Ms. Paltrow has presented evidence that a GoPro video of the ski collision may have existed, period, and everything else remains the same.
Yeah.
Okay.
Any other objections from the plaintiff to the jury instructions?
No, Your Honor, as we looked through them yesterday, we were like that.
Okay. How about the defense?